Hello, and welcome to this webinar series on the Bribery Act 10 years on. I am Dr. Colin King, Director of the Centre for Financial Law, Regulation and Compliance, or FinReg. And today's webinar is the first in a series of 5, which allow us to officially launch our new research centre here at IALS. FinReg was established in April this year and is primarily focused on legal aspects of financial law, regulation and compliance. We had organised a launch event on the Bribery Act for May, but of course due to the pandemic we had to postpone that conference. And our speakers from the planned conference have kindly agreed to take part in these webinars instead. Before introducing today's speakers, I want to briefly say a small bit about FinReg. The purpose of the centre is to promote knowledge and understanding of financial law, regulation and compliance broadly construed. To give some examples of that, we look at financial crime, we look at legal responses to such crime. Money laundering and bribery are two prominent examples. We engage with experts in other disciplines like criminology, psychology, business and politics. But we also put particular emphasis on engagement between academia and practice, including establishing a new position recently, a visiting professor of practice, which is currently held by Barnaby Hone of Drystone Chambers. And we do aim to ensure that our research is practice relevant, and that aim has led to what we hope is an interesting series of webinars on an important and developing area of financial crime. Our speakers over the coming 5 weeks come from a range of backgrounds, including academia, legal practice, enforcement and policy backgrounds. The series is kindly sponsored by the Institute of Advanced Legal Studies and also by the Society of Legal Scholars, and looks at what I think is a fascinating topical area. In recent weeks, we see quite a bit of activity from the Serious Fraud Office, including sentencing of individuals in the Unioil case and a DPA with Airline Services Limited. I make that 9 DPAs now so far. And also, we now finally have had the government response to the corporate liability call for evidence, but that has now been passed over to the Law Commission for further review. So again, we must wait a bit longer to see what happens in that regard. Today, we have a fascinating combination with a speaker from the Serious Fraud Office and a speaker from Spotlight on Corruption. Our speakers will talk for approximately 20 to 30 minutes, then we will open up to Q&A. Questions can be put in the chat box and we will put those to the speakers at the end. First up then, we have Miranda Cheng, who is a case controller at the SFO. Miranda leads a team of investigators, lawyers and forensic accountants in several high-profile fraud and corruption investigations. And of particular note is the ongoing investigation into the collapse of London Capital and Finance. So that is a fraud investigation involving losses in excess of £200 million and over 11,000 victims. That case has also been investigated by the FCA, and it also triggered a Treasury review into the wider mini bond market. Prior to her role as a prosecutor, Miranda was a long-standing criminal defence lawyer whose practice focused on bribery, fraud and money laundering investigations, both in the UK and abroad. Our second speaker is Dr. Susan Hawley, who is Executive Director of the UK charity Spotlight on Corruption, which monitors how the UK enforces its anti-corruption laws and anti-corruption standards. She has worked on bribery and corruption from a UK perspective for 20 years, having previously worked at the Corner House and Corruption Watch. And as the name Spotlight on Corruption implies, Sue plays a key role in keeping a spotlight on anti-bribery and anti-corruption efforts. So we are delighted to have both of you here with us today, and we look forward to your insights. So first up, Miranda, over to you.
Thanks. Thanks, Colin. Good evening, everyone. I hope you are all very well. Thank you so much for having me speak to you today about 10 years of the Bribery Act. So it's been 10 years since the Bribery Act received royal assent in April 2010. But of course, we are all aware that it then came into force in July 2011. 10 years ago, many things have changed, and looking back to 2010, I note that the most serious issues we were facing back then was a certain Icelandic volcano disrupting air travel for a few weeks, and issues with regard to the Greek Eurozone crises. Fast forward to today, and 10 years later, many things have changed. And the question that I've been considering today is, how has the UK Bribery Act, or the UKBA, developed over this time? Now, it's widely recognised that the UKBA remains the gold standard for UK PLC as to what is considered to be a model for corporate citizenry. The UK has retained its status under the Transparency International report for foreign bribery active enforcer. Now, it is only one of 4 countries out of a total 43 countries who are party to the OECD Convention that has achieved this distinction. That means that the UK remains a standard bearer for good compliance culture. And especially in these uncertain times, the Act provides, no doubt, clarity for both UK persons and businesses as to how we must behave in the conduct of business both here and abroad. A World Bank report was published recently regarding the fight against global corruption, and it states, news headlines over the last few years have been filled with global scandals involving corruption on an unprecedented scale. So for me, at least, this is a stark reminder that although we have achieved a great deal, the UK is not immune to the effects of power. It is not immune to the effects of politics and money. So with that in mind, what I would like to do today is to reflect a little bit on the prosecutions that we've had over the last 10 years and see where we've arrived at now as of 2020. Some of you may remember the first prosecution under the Bribery Act. That was Mr. Patel in 2011, who was I believe, a court clerk at Redbridge Magistrates Court, and he was convicted for altering court records. And unfortunately for him, he received a rather hefty 6-year sentence, which was reduced on appeal to 4 years. That then led to several other individual prosecutions, including a gentleman who was offering a bribe to a driving test official to pass his driving test. He received a suspended sentence. In 2014, this led to the SFO's first conviction using the Bribery Act. This was the Sustainable Agro-Energy case. It was a £23 million biofuel fraud. However, the CEO of the company was also convicted of accepting bribes. And this was considered by the sentencing judge to be an aggravating feature. And as a result, he received 13 years imprisonment. Now, turning to 2015, so 4 years after the Act came in force, we started to have our first corporate convictions. In 2015, we had the Sweet Group convicted of the failing to prevent bribery offence. And this was later followed by Skansen in 2018. And many of you will be familiar with this case, where it was a post-trial conviction for the corporate of failing to prevent bribery, and 2 individuals who also received prison sentences. Now, it's important to note also that the range of cases are not limited simply to those within business and industry. In 2019, we had a football coach from Barnsley Football Club, I believe, and several corrupt agents receiving suspended sentences. In 2020, this year, the NCA also successfully convicted 3 people in a cricket match fixing case. Colin mentioned in the introduction the Unaoil case, and indeed, whilst this was not strictly a Bribery Act offence, but under the Prevention of Corruption Act, the SFO secured 4 convictions this year for bribery, and that involved a conspiracy to give corrupt payments to secure oil contracts in Iraq. Now, some have commented that there have not been as many prosecutions, whether it be for individuals or corporates, as one would have hoped. Now, my view is that it is essential that we keep faith in the integrity of the legislation and the commitment of prosecuting agencies to use powers under the Act to their full effect. Having looked back at the cases, well, certainly these are reported cases, I should add, over the last 10 years, there's been a clear evolution or trajectory. So we've started with some relatively minor cases involving individuals. We then move on to convictions of larger scale offending in relation to frauds, the first corporate prosecutions, and indeed successful prosecutions in other known risk areas, such as corruption in sport. So in my view, this progression shows an upwards trend of the types of bribery and corruption cases that are being dealt with. And they are, over time, increasing in terms of their seriousness and significance. Now, in any conversation about bribery, it's difficult to ignore the impact of corporate criminal liability. So I'm going to deal with it briefly today. Members of the SFO gave evidence in the Select Committee's review into the Bribery Act. And on this issue, our view is this: the identification principle leads to the inequitable position that it's far easier to fix small owner-managed companies with the requisite knowledge and intent than the large multinational corporations. On this issue, again, the MOJ opened its consultation on corporate criminal liability back in 2017, and the government's response was published recently on the 3rd of November. And the outcome of that was the referral of the corporate criminal liability matters to the Law Commission for further review. We certainly welcome this announcement, and we are certainly in favour, in particular, of the introduction of a failure to prevent offence for economic crime. And the need for this area can be illustrated simply by what happened in the Barclays Qatar case. And in that judgment, the issue has become more acute for law enforcement officials such as us, because the judgment confirmed the narrow application of the controlling mind test. And indeed, this makes it very difficult for us to hold companies with complex governance structures to account for alleged fraudulent conduct. Some say that the proposed offence is too broad, that it's therefore not comparable to the effectiveness of the Section 7 Bribery Act offence, which by its very nature is more tangible. However, in the 10 years since the introduction of the Bribery Act, investigators across the UK now have an expanded arsenal and toolkit, and these include measures such as account freezing orders and unexplained wealth orders. in my view, the failure to prevent economic crime offence would be wholly complementary to our existing suite of investigative tools. But until such time, and if that happens, the current Section 7 offence under the Bribery Act for failing to prevent remains one of our most vital tools to hold corporations to account. And indeed, this was demonstrated via the convictions of the Sweet Group and Skansen for this offence. I should also note that in terms of evaluating the success of the Bribery Act, we should also recognise that the Section 7 offence has also been used as a model in the Criminal Finances Act for the offence of failure to prevent the facilitation of foreign tax evasion. The impact of the Bribery Act extends beyond simply our jurisdiction. Malaysia has recently inserted a new amendment to its existing anti-corruption legislation, which provides for the first time the ability to prosecute corporates if an associated person engages in corruption. And there is also a defense of adequate procedures. This legislation was explicitly modeled on our Bribery Act. Furthermore, Australia in August this year also published a Law Commission report proposing a raft of measures dealing with corporate criminal liability and various new offences to consolidate the existing regimes across Australia's states and territories. Australia, interestingly, is also proposing to introduce the failing to prevent offence, not just for bribery, but extending to other offences such as foreign tax evasion and modern slavery as well. So, deferred prosecution agreements, DPAs under the Crime and Courts Act, are an essential partner, as we all know, in the fight against bribery and corruption. It is an evolving area of practice, and with each case, as it comes before us, presents us with unique challenges. To date, the SFO has now entered into 9 DPAs, 6 of which involve Bribery Act investigations. We have, in this time, also published additional guidance. Firstly, guidance on corporate cooperation. And secondly, for the purposes of transparency, we've also published our internal staff guidance called the Operational Handbook on DPAs. Now, I regard the publication of this guidance is, in effect, a direct response to some of the comments in the Select Committee report, which emphasised the need for agencies such as the SFO to make it very clear what we expect to amount to genuine cooperation and what we expect amounts to a genuine commitment to a change of corporate culture. As a case controller, this is certainly very helpful because it provides me and my colleagues with a clear pathway for corporates to be able to engage constructively with us. There is now a set of non-prescriptive standards which we can transparently and openly discuss indicators of corporate compliance. In terms of the guidance, we've made clear that cooperation means providing assistance that goes above and beyond, and that includes identifying suspected wrongdoing and criminal conduct with the people responsible, regardless of their seniority. It means reporting within a reasonable period of time and preserving evidence in an evidentially sound format. Helpfully, the guidance also confirms our position in relation to the waiver of legal privilege in relation to witness accounts. And as we are no doubt aware, practitioners and academics alike, considerable weight is given to the disclosure of accounts given by witnesses. And this guidance confirms that failure to waive privilege in of itself is not considered to amount to non-cooperation. the operational handbook, which was also published very recently, gives us further details as to what we consider to be reporting within a reasonable time. We talk about the contents of the statements of facts. We deal with the issue of naming individuals and the problems that may arise, especially in relation to those who have not been charged or convicted. It also deals with some of the issues that we encounter when dealing with parallel investigations. So in relation to the impact of DPAs and their effect on the investigation of bribery, again, Colin mentioned the most recent DPA that has been signed, and I think that was perhaps about a week and a half ago. That was the airline services matter, which a colleague of mine dealt with. And this is a fairly straightforward case of what I call classic bribery, which was the use of an agent to secure valuable contracts between, I think, 2011 to 13. Now, Airline Services was a company that unsurprisingly provided airline services to various airlines, including Lufthansa, and they manufactured various airline parts. And the use of Agent 1 to secure contracts and to compensate them with a share of commission formed the basis of the DPA that was entered into. The judgment notes that Airline Services showed a woefully inadequate bribery and compliance procedures. However, due to, amongst other things, the self-report by the company, the fact that it was done on a timely basis, and the fact that they actively cooperated fully with the SFO, deemed it appropriate by the court to sign off on this particular DPA. And speaking of airline cases, I must mention also the Airbus DPA, which of course is one of the largest global settlements, which was about over 3 billion euros across UK, US and France. The UK side of the investigation concerned a failure to prevent bribery matter. It was an excellent example of cross-jurisdictional cooperation. Now, the Bribery Act certainly had a role to play in this, given the Section 7 offence. Having this available as an offence facilitated a focused investigation that could be managed well in parallel with the other matters that were being dealt with in the other countries. In terms of corporate versus individual prosecutions, what I will simply say is this: the SFO remains committed to investigating and prosecuting individuals where it's appropriate to do so. And our recently published guidance makes this very clear. I note there has been a fairly recent case, that of Sorby and Leak. I think if it wasn't this year, it was late last year. And that was a bribery matter as well. Individuals were prosecuted, although ultimately the jury did not convict in that matter. So, in conclusion, it is right to say that the select committee findings, which were that the UKBA remains the gold standard for the international fight against bribery and corruption. And bearing that in mind, it has enabled the SFO to continue to investigate the most serious cases of bribery and corruption. However, I note and accept that this is an ongoing process. One cannot expect results overnight, but we have learned many lessons in the last 10 years. Overall, the legislation has been extremely effective, and certainly within UK businesses, and putting on my former defence hat on, I can say without a shadow of a doubt that it's been an overwhelming force for good. It has prompted a lot of structural changes across multiple industries to improve governance, and to promote a culture of good behavior and compliance. As to where we go in the future, no doubt these are uncertain times. We are going to be facing some rather drastic economic consequences in relation to COVID. There has already been published, both in the UK and abroad, the risk of the high risk of fraud relating to COVID and various COVID contracts. Now, law enforcement, we do need the appropriate tools that will enable us to keep up with this pace of change. And certainly the Law Commission's review on corporate criminal liability, we certainly hope that this review will provide us with greater clarity in the future. Thank you very much.
Cheers. Thanks very much, Miranda, for that fascinating discussion of how the law has developed and how it has been applied in practice by the SFO over the past 10 years. And we pass over now to Sue for your thoughts on the Bribery Act.
Many thanks, Colin. I'm going to share my screen because I've got a funky PowerPoint to share. Let me just check I've got the right. No, that's the wrong one, isn't it? Sorry, many apologies. Yes, is that right, Colin? Great, thank you. So that was, I will cover some similar ground to Miranda, but with maybe a slightly different perspective, because we do court monitoring at Spotlight on Corruption, and we sit in quite a lot of these cases and look at what are the implications of the cases for the law and how it develops. And I think, as Miranda implied, the Bribery Act is great, but it is still very much work in progress. I thought it was worth kind of recapping about what exactly was new about the Bribery Act compared to the old Prevention of Corruption Acts. And I've put them here, obviously the top one is something Miranda referred to, which was corporate liability and the Section 7 offence, failure to prevent. That has obviously been used quite a lot. The second thing that was new about it was the creation of a specific foreign bribery offence, Section 6, which has been used not at all, which was something that the Select Committee, the House of Lords Select Committee Miranda was referring to, kind of mentioned and looked into. A key aspect was the explicit extraterritorial jurisdiction, Section 3, and this has been really important, and I'd say fairly well used by the SFO. Another aspect was the senior officer accountability offence at Section 14, which has not been used at all, as far as we can see from any of the cases so far. And then finally, the removal of the Attorney General's consent for corruption and bribery prosecutions, which was really key, as we've seen from recent controversies around old Prevention of Corruption Act offences, which still have to be signed off by the Attorney General. There was some discussion at the Select Committee about whether the replacement of that consent with a director level consent was still playing a kind of downward pressure on prosecutions in this area. But I'm not sure. I think that wasn't seen as strong enough to make a recommendation in that space, but the committee did note that. So what's wrong with the Bribery Act? What's wrong with this perfect model piece of legislation? There's no doubt it is an excellent piece of legislation. Not everyone does agree, though. Interestingly, just in September this year, a legal blog by Simmons & Simmons said that some people consider it a missed opportunity that has generated few convictions and had little practical effect, which seems rather harsh. But there are, in our view, some ongoing weaknesses with the Bribery Act. And the key one is that the identification doctrine still applies to the main or substantive offences in the Bribery Act, so sections 1, 2 and 6. And the problems with this doctrine are well known, and it's now really the kind of key focus of the Law Commission's review that was announced last week. But the reasons why we think this is a problem is that while a large company can be convicted for a failure to prevent offence, small companies could be convicted for both a main offence and a Section 7 offence. And the emerging case law from DPAs is that a failure to prevent offence is a lesser offence and it incurs a lesser penalty. And the second problem with that, which is not a problem with the Bribery Act itself, but kind of an implication of that, is that while a Section 1 or Section 2 or 6, mainly Section 1 and 6, do incur mandatory exclusion from public contracting, a Section 7 offence does not. So even within the current Bribery Act, which tried to resolve corporate liability problems, there's an unfairness. And we've heard this from prosecutors that, with a small company, a prosecutor could say, look, if you really play ball, we'll only do you for a Section 7 offence. If you don't, we'll do you with a Section 1. And then you're really going to face the consequences. Whereas they just can't play that kind of hard ball with larger companies. So we think that the Law Commission definitely needs to look at how the identification doctrine applies even to model pieces of legislation like the Bribery Act. So, but it's also, I think, probably important to remind ourselves that not everyone is on board with the Bribery Act. I think generally there's broad support in business, but there are bodies representing the small and medium-sized enterprises which have been very, very opposed and do regard the Bribery Act as having reduced UK competitiveness and put in place kind of obstacles for these companies to export. And some of those views actually were amazingly kind of openly aired by some of the members of the House of Lords Bribery Act Committee. Not many, it has to be said, but there were one or two who definitely took the view that this was really damaging British business. And it was enough of a concern that back in 2015, we found out that government officials were actually engaging in a kind of informal one-sided consultation with business groups. And they were going around saying, are there any problems with the Bribery Act? And what was really interesting was that we did a Freedom of Information request to find out what businesses had been saying. And the vast majority of the big companies came back saying, no, absolutely not a problem. This is how things are now. This is the global trend. And there were, however, one SME association who said, look, bribery is just how you have to do it overseas. It's a normal part of doing business. And, that's how it is. And so they were clearly pushing back. What was interesting is that the government officials chose to do that consultation, having just done a survey or released a survey of SMEs, which found that actually 90% didn't have any concerns with the Act and 89% said it hadn't impacted on their ability to export. So that suggests that some of the SME kind of trade bodies are a bit out of step with, the broader SME community. But I think, Miranda's just referred to the kind of economic headwinds that we're, facing. I think as well with Brexit, we've done an analysis recently in relation to UK export finance of the kind of markets that British companies are going to be heading into. And they're high risk from a corruption point of view. And they're going to have to replace EU business for a lot of companies, particularly if we leave the EU without a deal. So I think we could start to see a little bit more of that background noise is how it was described in this consultation by government officials, where people are complaining a bit about the potential for the Bribery Act to kind of cost them exports and impede their ability to operate in these high-risk markets. Sorry, I have just turned my screen share. Here we go. Just turning my emails off so they don't ping anymore. Right, so enforcement. So as we all know, just to state the obvious, a law is only as effective as its enforcement. And I think it's worth kind of noting, kind of in passing, that although the Prevention of Corruption Act was widely seen as not fit for purpose, it continues to have fairly good rates of enforcement. So 5 out of 6 of the SFO's corporate prosecutions in the last 5 years or so, as opposed to DPAs, this is convictions, they've resulted in 4 corporate convictions, and they were for Prevention of Corruption Act offences. And I think one of the surprising things to come out of the House of Lords committee report was actually that the CPS is still charging way more Prevention of Corruption Act offences than Bribery Act ones. So it was 107 compared to 42, over double in that period of 2014 to 2018. So, on the one hand, that suggests to us that where there's a will to prosecute, you've got slightly tricky legislation, there's a way. As Miranda kind of hinted, and as the Simmons and Simmons kind of blog suggested, there is a kind of sense that Bribery Act enforcement has been fairly slow, which is perhaps surprising given the kind of model nature of the legislation. And I think that this could be because it definitely does take longer for this kind of evidence of a bribery and corruption to emerge. And longer to build a case, because these are really complex cases involving having to follow multiple leads, often overseas. It's a hidden crime, so it's hard to investigate and prosecute. I think there's also an element where prosecutors, particularly in the CPS, have been taking their time to get their head around how to use the legislation compared to offences they're used to, like fraud by abuse of position, which is what some of the CPS lawyers have said to us, is that, it's an easier offence to prosecute because there's no requirement for consent, and it's just how it's been done. So there's a kind of cultural shift that has to take place. I don't think that's true of the SFO, but I think that might have been more true at the CPS. So then we come on to deferred prosecution agreements, which I put here are part of the solution, and also part of the problem, in our view. So the vast majority of the corporate offences under the Bribery Act, the Section 7 offences, have been resolved by DPA, as Miranda mentioned. So that's 6 out of 9 Section 7 cases have been resolved by DPA. There was 1 guilty plea, 1 conviction after a contested trial, and 1 acquittal. So why this is good? There are good aspects to this. DPAs for bribery have brought in over $1 billion in revenue for the UK Treasury, 1.3 billion, a lot of which was the Airbus DPA that Miranda referred to. DPAs are really good at getting quick and easy results without lengthy court proceedings. And they're also really good at extracting real corporate reform out of companies. It's a real problem that court cases are tricky in this case, as we've seen with quite a lot of the prosecutions of individuals that relate to some of these DPAs, where we've seen a spate of acquittals. And these are kind of for quite complex reasons. Sometimes this is because juries don't seem to have much interest in corruption overseas. Sometimes in our experience, judges can be quite erratic in how they approach things. And finally, a really key one for us is that actually courts don't have any power to impose any kind of corporate monitorship. I should say they could through a serious Organised Crime and Prevention Act, but the bar for using one of those for corporate monitorship is very high and has never been used, as far as we're aware, by any of the prosecutors, because you'd have to prove a real risk of reoffending. Whereas that's not at all the case of a DPA. So you've got a kind of system where a court conviction could actually be a more lenient option than a DPA. And you hear this quite a lot from people in the legal community, that, you know, there's a kind of sense of why should we tell our clients to go and negotiate a DPA when actually if we, you know, sit this out in the court, we might get off, or we might get an easier deal. And that's something that's not the SFO's fault. And I'd like to say up front, I think it's really problematic that every time the SFO loses, they get hit really hard and slated in the press. And it isn't all about the SFO. It's sometimes about the court system and how it deals with these things. So why are DPAs also part of the problem? So one of the problems is if you only do things by DPA, you don't get much case law. I mean, there is DPA case law, but you don't get the kind of really tricky, complicated, nuanced stuff that comes out of contested trials. And that's particularly the case for things like adequate procedures and some of the kind of more thorny issues. The other reason we think DPAs are a problem, it's not DPAs themselves, but about how they're being used, is that the bar for getting a DPA seems to be getting lower and lower. So when they were introduced, you had to have self-reported and cooperated. But recent cases like G4S suggest you don't even have to really have cooperated from the beginning to get a DPA. And I would say we're a bit concerned that, you know, that's not really going to incentivize companies to self-report, because they're going to think, if I sit on my hands and wait till the evidence, let's see the shape of the evidence before we really start to engage with the prosecutor. So, I mean, we're a bit concerned that that means you're likely to see a reduced number of self-reports and a reduced number of cases at the SFO as a result. And then the other part of the problem is that, you know, as I've kind of hinted with the court cases reference, DPAs only really work if companies know that if they don't cooperate and self-report, they're going to get a far worse beating in the courts. And that's not what's happening at the moment. And that's the kind of missing part of the equation to make them really work from our point of view. Moving on. Is overseas bribery still a priority? So one of the kind of quite a lot of noise been coming out in the press and the legal community about, you know, is the SFO actually, does it really care about corruption and bribery anymore? You know, is it actually mainly going to focus on fraud from now on, and more like domestic fraud, which has a lot of victims? And I think it's probably fair to say that prosecutors do face pressure to deliver certain government priorities, and that the government priority now has shifted to fraud, and that's likely to increase with COVID. And we've seen a real shift, you know, with the anti-corruption summit in the UK, overseas corruption was a priority. Then the shift went to economic crime and money laundering, and now the shift is fraud. I mean, I think there is maybe a bit of concern about what will happen to overseas bribery. Will it take a back seat? You know, I noted Miranda's kind of reference that we need to, you know, to have faith that the prosecuting bodies do have will in this area, which we do have. But I think it's worth noting that, you know, there have only been 2 new bribery investigations announced in the past 2 years. That's publicly announced. So that doesn't mean they're the only investigations going on, obviously. 4 have been dropped. And that's obviously part of the kind of process of the new senior management leadership weeding out cases they don't think are strong enough. And we're still awaiting the outcome in 5 cases that were open prior to 2018, which we haven't heard anything about for a while. I think the concern is that we might see more bribery enforcement outcomes, but this is just cases feeding through that were open prior to 2018, and that, you know, are we seeing the kind of new cases coming in that show that overseas bribery is going to carry on being kind of enforced proactively. And I think it's really important to point out that the SFO is not the only one that holds responsibility in this space. It does the top level stuff, but you have the NCA's International Corruption Unit, which is meant to do more the lower down mid-tier stuff. And it has yet to bring a single foreign bribery prosecution, which is somewhat in contrast to its predecessors, the City of London's Overseas Anti-Corruption Unit, which brought 13 convictions of individuals and 1 corporate conviction for overseas corruption. So we're quite concerned about what's going on in that kind of middle tier and who is doing the lower level overseas corruption stuff. So I think it is worth pointing out that the UK only just made it back into the active enforcer category. That of Transparency International's exporters ranking of how countries enforce the OECD Convention. And that was a little bit worrying for us, if I'm honest, because it would be a massive reputational hit for the UK if it was downgraded from an active enforcer. I think it's worth pointing out that domestic bribery and corruption it's been definitely the poor orphan in this space, and it's been getting a bit more attention, but there's always been an issue that there's been no one enforcement body tasked with enforcing domestic corruption. And there's been no reporting mechanism either, which is about to change. So the government are meant to be introducing a reporting mechanism for corruption this year, although to be honest, that's only going to be really useful if there's a dedicated enforcement agency that's going to be picking up the cases that come through that reporting mechanism. I think one of the surprising findings to come out of the House of Lords Bribery Act review was that there were more misconduct in public office offences being prosecuted in the Bribery Act as well. So in 2017 and 2018, you had 106 such offences, although it's important to note that kind of conviction rates have been getting lower as prosecution rates have been going up. The Law Commission is meant to be releasing its report on misconduct in public office reform anytime now. I think it's somewhat overdue, in fact. And one of its recommendations is that there's a new offence of official corruption. So it'll be interesting to see what that does to kind of domestic Bribery Act enforcement, and whether, actually it's going to create a whole new area of enforcement on the domestic front rather than more Bribery Act prosecutions. So just to sum up, because looking forward to lots of interesting discussion with all the interesting people who have been joining in the conference. So I think, as Miranda said, it's widely acknowledged that the Bribery Act has changed corporate behaviour. But it's probably also true that, as many people have observed, it'll only continue to do so if there's proactive enforcement. I think it would be useful if there was a bit more kind of transparency, and this is where actually a greater transparency in kind of when investigations are dropped, which is something we don't see much of. At least the SFO are transparent that they have dropped an investigation. We don't get that from the NCA. But it would be useful to understand what are the factors that stop cases either being picked up for investigation or dropped once they are being investigated. I think with Brexit, it's clear we are entering into a quite risky period for when companies might start engaging in more high-risk behaviour to get new business in risky markets. So it's really important to keep overseas bribery as a priority. And then I think it's also worth keeping an eye on this domestic corruption space and what happens once a new anti-corruption reporting line is established, and what that means for enforcement, both for Bribery Act, but also if there's a new offence from the Law Commission. So thank you very much.
Cheers. Thanks very much, Sue. And you're certainly living up to the name, keeping a spotlight on corruption. And thanks to both of you for such a fascinating insight into how the Bribery Act is operating in practice.